4 months before Professor Peter Hindmarsh took the stand in the Lucy Letby trial, he had already been quietly let go from the Great Ormond Street Hospital for Children. The jury never knew. The defence didn't either, not for weeks. In the trial, Hindmarsh's evidence is the moment his influence became dominant, where expert gravity turns into expert monopoly. That isn't a glitch, because in the absence of direct evidence, the system fills the silence with inference and accusations. The cases of Folbigg and Letby show what happens when nobody stops it. Let me show you exactly how that happens, starting with the evidence itself. In a homicide prosecution, there are things that the jury expect to see: a witness, a confession, a weapon. Neither the Letby case nor the Folbigg case had any of them, and that's not an irregularity. 2 cases, 2 countries, 16 years apart, same empty table where the evidence should have been. In the Letby trial, there was no witnesses to any act of harm, no observable assaults, no medically proven mechanism of harm, not one that could explain how a supposedly healthy infant was killed without leaving a trace. The prosecution's medical theories were not established science. They were hypotheses presented as conclusions. And since the trial, an international panel of specialists has rejected many of them outright. What remains is statistics, patterned evidence, and a dangerous assumption that when babies die in the presence of a nurse, the nurse must be the cause. The Folbigg case is the same story, told 16 years earlier. No witnesses, no observable acts, no established mechanism of homicide. And the science that came later, genetics, immunology, and the very disciplines the original trial never heard from, now points to natural causes of death for the 4 children. Same structure, same absence of proof, same result. So if the evidence wasn't there, what was? Well, that's section 2. When direct evidence is absent, someone has to explain what happened. The jury need a story. The prosecution needs a theory. And in both of these cases, the gap was filled the same way, by experts who spoke beyond what their discipline could support. This is not a new problem. Sir Roy Meadows, a British paediatrician, not a statistician, told a jury that the odds of 2 infants dying of natural causes in the same family were 1 in 73 million. Now, this statistic is mathematically indefensible. It was just simply wrong, but it helped to convict Sally Clark. She served 3 years before her conviction was overturned. She never recovered. She died of acute alcohol poisoning 4 years after her release. You would think the system would learn, but it didn't. Meadows wasn't the last, and Britain wasn't the only country where this happened. In Canada, Dr. Charles Smith became the country's most trusted voice on suspicious infant deaths. For more than a decade, his testimony sent parents to prison. The Gouge inquiry found that Smith's work was deeply flawed, scientifically unsound, and enabled by systemic failures in oversight, failures that had devastating consequences for the justice system itself and the people who were wrongly accused. The Letby case fits this pattern, not approximately, precisely. A small group of clinicians, some working outside of their core expertise, some offering speculative mechanisms, one under active General Counsel investigation, became the authoritative voice on what happened to those infants. Their interpretations were treated as definitive. Dissent was dismissed, and the same thing happened to Folbigg. A narrow expert frame elevated to unquestioned authority, built on a presumption of homicide in the absence of proof. Here's the formula. It's not complicated. Expert monopoly plus institutional deference equals untested evidence presented as fact. The danger is not that experts make mistakes, because, well, experts do make mistakes. We all do. The danger is when the system stops testing them, when authority replaces scrutiny and the presumption of innocence yields to the presumption of expertise. But this pattern has a face. In the Folbigg case, the name was Dr. Allan Cala. Let me show you how this one expert became the entire case. Now, the Folbigg case illustrates what happens when a single opinion acquires enough authority to redirect an entire prosecution. I call this expert gravity, the point at which one interpretation becomes the centre of the case and everything else, dissent, alternative explanations, emerging science, gets pulled into its orbit or pushed to the margins of the case. The gravitational centre here was Dr. Allan Cala, the forensic pathologist who conducted the autopsy on Laura, the fourth and final Folbigg child to die. Dr. Cala found Laura had myocarditis, an inflammation of the heart muscle, which can be fatal, but he recorded that the cause of death was undetermined, in light of the prior deaths of the other three siblings. His colleagues simply disagreed. Professor Hilton indicated at the 2023 inquiry that he would have certified myocarditis as the cause of death. Professor Caldner, one of Australia's most respected forensic pathologists, agreed. That was the precise moment that the evidence stopped leading and started following. During her 2003 trial, the prosecution relied on the same pattern-based reasoning that underpins Meadows' law, the idea that multiple infant deaths in one family are inherently suspicious. At the inquiry, Folbigg's legal team argued that this pattern-based logic had infected the original prosecution case. Interestingly, during the inquiry, Dr. Cala's position shifted. He acknowledged that he could not exclude myocarditis as a cause of Laura's death. The former New South Wales Chief Justice, who led the inquiry, the Honourable Tom Bathurst, concluded there was a reasonable possibility that all four children had died of natural causes. He also found that the prosecution's case on the fourth child had relied on coincidence and tendency reasoning, and that could no longer be sustained. Dr. Cala's role matters not because he acted with malice, but because the system permitted a single expert to become the case's organising logic. Because once that centre is formed, the court's capacity to test competing explanations collapse. That is the real danger of expert monopoly, not bad faith, but unchecked authority. And this isn't just an Australian problem. The same structural flaw appears in the Letby case, with one crucial difference. You already know the headline, Hindmarsh was let go from Great Ormond Street Hospital before he testified, and the jury was never told this. But what you don't know is everything else that was kept from them, simultaneously on the very day that he took the stand. Let me pause here for a moment, because what I'm about to tell you about Professor Hindmarsh is not disputed. It's documented, every word of it, and the jury, the 12 people deciding Lucy Letby's fate, heard none of it. Just as Folbigg's prosecution relied on a narrow circle of experts, the Letby trial leaned heavily on a small group of prosecution-aligned clinicians whose interpretations were later challenged by UK and international specialists. One expert in particular, Professor Peter Hindmarsh, is now a focal point of concern. Before the trial, Hindmarsh's honorary contract at the Great Ormond Street Hospital had been terminated 4 months before he took the stand. He remained employed at the University College London hospitals, but the termination was not disclosed to the police or prosecutors before his initial testimony. Then, on the very day he first gave evidence, the General Medical Council opened a fitness to practice investigation. A medical tribunal soon imposed interim restrictions on his work, warning that he may pose a real risk to the public and that the allegations may have the potential to impact on his ability to act as an expert witness. Hindmarsh disclosed the GMC investigation to police on 14 December 2022, nearly 3 weeks after his first appearance. The Crown Prosecution Service waited a further 2 months before informing the defence and told them it would oppose any disclosure to the jury on the basis that the allegations had not yet been adjudicated. So the jury heard none of it, not the termination, not the investigation, and not the restrictions. Hindmarsh returned for a second appearance. In February 2023, the investigation was still open. The jury still had not been informed. In late 2024, Hindmarsh voluntarily removed himself from the medical register, and this ended the GMC investigation without a finding. When the credibility of the expert collapses after a verdict, the verdict itself cannot and it should not remain untouched. Let me pull these two cases together, not by what they share, but by what the system chose not to share with the people deciding guilt or innocence. In the Folbigg case, the reviewing pathologist, Professor Hilton, disagreed with Dr. Cala, the pathologist who performed Laura's autopsy. He would have certified myocarditis as the cause of death. Another of Australia's leading forensic pathologists agreed. The disagreement between the man who conducted the autopsy and whose opinion became the case was never properly tested at trial. In Letby, Professor Hindmarsh gave crucial evidence while under active investigation with formal restrictions on his practice. After his hospital contract had been terminated and the jury was told none of it, unanimous verdicts of 2 charges relied heavily on his testimony. And the 12 people whose job it was to decide did not know. These aren't oversights, they're decisions made by institutions built to prevent exactly this. And here is the question that cuts across both cases, 2 countries and 2 decades. If the system cannot be trusted to disclose the weaknesses in its own evidence, what exactly are we asking juries to do? Guess? The question isn't academic anymore, it's more practical. When the science can't give a definitive answer, when the best experts in the room disagree, or when the evidence simply isn't there, what does the justice system do? I think there are 5 things, so let's start with the first. Expert opinion is opinion. It might sound obvious, but in both these trials it wasn't treated that way. An expert says, I cannot exclude foul play, and somehow that becomes evidence of foul play. That is not science, that's speculation, wearing a white coat. The second follows directly. When science is incomplete, you don't narrow the expertise, you broaden it. In the Folbigg case, no geneticists testified, no immunologists, no cardiac specialists. In Letby, no independent neonatologist was called to review the notes, no toxicologist, no metabolic expert, and these were not coincidences. They were choices. And when you only hear from one kind of expert, you only get one kind of answer. The fix is not complicated. It's more expertise earlier in the case from more disciplines. Now, if that sounds obvious, ask yourself why it happened in 2 cases in 2 different countries. Now, the third is where the system consistently breaks. Unexplained is not a legal synonym for suspicious. A death without an established cause is exactly that, unexplained. It's not evidence of homicide. In both the Folbigg and Letby case, the prosecution's entire case was built on collapsing that distinction. Unexplained deaths became suspicious deaths. Suspicious deaths became, in the jury's mind, murder. That is not a logical chain. It's a rhetorical one, and the justice system is supposed to be better than rhetoric. And here's the uncomfortable part. Both prosecutions knew this distinction. They allowed it to collapse anyway. That's not a mistake. That's strategy. Now, fourthly, when science is silent, the presumption of innocence does not get suspended. It does not yield to pattern evidence, narrative coherence, or the confidence of a single expert. It exists for moments like this when the evidence is incomplete, contested, or unclear. It's not a principle that operates only when proof is strong. It operates because proof is not strong. Let me say that again, because this is where everything turns. The presumption of innocence does not yield to pattern evidence. And the fifth, courts must be alert to expert monopoly and what I've been calling expert gravity. When one voice becomes the centre of the case, dissent is crowded out. The illusion of certainty takes hold where none in fact exists. The answer is not deference. It is an independent review, peer challenge, and judicial insistence on scientific humility. Let me put this plainly as I can. When the science cannot answer the question without sufficient confidence, the justice system must be willing to say so and to act on it. We do not know is a legally valid conclusion, and where we do not know, we cannot convict. These cases reveal a structural flaw, not a series of isolated mistakes. When science is incomplete, the system should pause. Instead, it accelerates, relying on narrow expertise, untested assumptions, and confidence where evidence should be. The proper course is restraint, multidisciplinary scrutiny, transparency, humility, and the courage to say, we don't know. Because when the cause of death is uncertain, the only lawful conclusion is uncertainty. And when we don't know, we cannot and should not convict. I can't put it any clearer than that. Tell me in the comments, is this a failure of individual experts or a system designed to defer to them? I'm planning a future series. Let me know if there's something you would like me to cover. And in the next episode, we go further. This is where we explore a dangerous blind spot in the justice system, the use of personal diaries as evidence when a system starts treating private thoughts as proof of guilt. Hit subscribe so you don't miss it. And if this resonates with you, subscribe, and I'll see you in the next video.